the same states that say that this is a matter for international courts or tribunals are the same states that will not utilize those same mechanisms that are available because, of course, then it might get categorized and then you have to do something.
No one can act with impunity.
These are crimes that are beyond the pale.
We are talking about human beings. We're not talking about numbers.
We need a court. That's as simple as that.
This is Asymmetrical Haircuts, your international justice podcast with Janet Anderson and Stephanie van den Berg.
All rise.
Hi, Steph.
Hi, Janet.
So a quick intro, because we've got 3 guests today and we want to hear from them all. The subject matter is atrocities and how you get states, particularly, to live up to their obligations about recognising, preventing, prosecuting atrocities, international crimes, genocide, crimes against humanity, war crimes.
We're squeezing this recording in just before a new initiative is launched, and it will have been launched by the time that this goes out. But we have a new organization called the Atrocity Crimes Standing Group.
Yeah, they're clear they don't want to be called an organisation at the moment. That's my fault, the way that I've written the script. So we're going to call it an initiative. It's very UK-based. What we've seen from the press kit, thank you for sharing, is what I would call the great and good of the United Kingdom, members of Parliament and House of Lords and some academics. And they've all been signing up to this new pressure group.
And what we really want to understand is more about how the levers of power really get pushed. Who do you kind of try to get atrocities acknowledged? And how do you get policy to shift as a result? Or maybe even get somebody to do something before the atrocity can actually take place? Could this really work to help stop, for example, a genocide from happening at all?
So let's introduce our cast of characters. We have Aarif Abraham. Hi, Aarif.
Hi, Janet. Hi, Steph.
And Aarif is a barrister at Doughty Street Chambers, and both Steph and I know you via the work that you've done for Lithuania, and you were involved at a session in The Hague on referring Belarus to the ICC on behalf of Lithuania. Steph, over to you.
And we have Eweli Ochaub. You will have heard her. She's a friend of the pod. She's a co-founder of the Coalition for Genocide Response, and you may have heard her when we had her on a few years ago to talk about recognizing the genocide on the Uyghurs, whether this is a genocide or not.
Hello. Thank you very much for having me.
And we also have Christine Chinkin, and she was the London School of Economics founding director of the Centre for Women, Peace and Security. And Christine, my goodness, you don't know this, but you've long been on my list of people that we would love to have on the podcast because you're a very significant figure in this field. I think I had you down in relation to the Women's Tokyo Tribunal. So maybe at some point we'll get you back on, but let's just concentrate on the matter at hand. What we want to do is to try and kick off with an outline of where we are at the moment in the United Kingdom, what's in place at the moment in terms of dealing with this field. I mean, we're not talking about a lawless state here. There's plenty of laws in place, and there's plenty of politics that goes on. So should we start with the Genocide Convention? I mean, 1948, UK signed up to that. There are some obligations that flow from that, are there not? And is the United Kingdom actually abiding by those obligations? Evelina, you've got genocide in your title. Why don't you kick us off?
Of course. And on the UK responses to genocide, I've been working with Lord Alton for close to 10 years. We started working together around December 2015, and that was in response to the Yazidi genocide.
Just to remind people, Lord Alton is a name that we see coming up again and again. I've come across him in relation to North Korea. You're talking about Yazidis, Uyghurs. This is a significant member of the House of Lords. David Alton, am I correct?
Yes.
So explain a bit further.
I have been working with Lord Alton of Liverpool for close to 10 years on atrocity prevention. Lord Alton of Liverpool is a peer in the UK House of Lords. He is also now the chair of the Joint Committee on Human Rights, and he's been doing incredible work, especially introducing legislative changes to ensure that the UK law is fit for its purpose of preventing and responding to such crimes as genocide. And as we've been working on the situation as back then of the Yazidis, we of course realized that certain duties under the Genocide Convention are in the law, but unfortunately, this is not enough to ensure that the duties can be implemented. And just starting very briefly with the duty to punish. Of course, the crime of genocide is criminalized in the UK law. The existing law right now is the International Criminal Court Act from 2001. And it enables investigation and prosecution of the crime of genocide. But at the same time, the law is very limited. And UK courts can investigate and prosecute genocide if committed abroad, only if committed by UK citizens and residents. So that's a very narrow understanding of the principle of universal jurisdiction there. So this is something that we've been hoping to change. And indeed, there will be an amendment tabled very, very soon that is to remove the requirement of citizenship and residency. So that's only in relation to the duty to punish the crime of genocide. But then a lot of work that we've done was in relation to the duty to prevent genocide. And whenever we raised any situation with the government, and that started, of course, with the Yazidis, but then with the Uyghurs, with the Rohingyas, with Tigrayans, and the list goes on. The UK government's response is that it's not for politicians to make a determination of genocide, but it is for courts. At the very beginning, the position was it's for international courts, but we managed to challenge it because, of course, in the case of the Yazidis, there was no international court able to make this kind of determination, especially as the International Criminal Court didn't have territorial jurisdiction to engage on the issue. And the then prosecutor rejected the option of looking into the personal jurisdiction of Daesh fighters who were citizens of member states, the Rome Statute. So because of that, the government said, okay, it can be any competent court. But again, we needed a court to make this kind of determination in order to recognize the atrocities as genocide and then act upon.
I wanted to ask Aarif and Christine, from what Eweli is saying, there are these obligations that the UK has, but they are a lot related to the Genocide Convention. And then you can have this debate on whether this is genocide. So is the idea then, if you have this standing atrocities crimes prevention group, that we don't have to have this discussion on what if it's genocide or not before we can do something, but that we should act in any case? Christine?
Well, the Genocide Convention is very clear that it's prevention of genocide that is important. And clearly, there is no point in having to say you've got to wait for a genocide to happen before that obligation kicks in. And the International Court of Justice has been, in the case involving Bosnia and Serbia, has essentially said that the parties to the Genocide Convention's obligation arises when there is a serious risk that genocide will occur, and that it is then an obligation of due diligence, essentially to take all reasonable measures within the country's capability, to prevent such genocide happening. And the court has also gone on to say, and this is the International Court of Justice, not the International Criminal Court, the International Court of Justice has gone on to say that this is an obligation of conduct, not an obligation of result. A country can't say that it didn't act because it didn't think that its actions would have any effect. Essentially, it has got that obligation to take reasonable measures within it when there is a serious risk of genocide.
But we have all this already, and we have this jurisprudence, and we have everything like this on the table, but still then countries are not doing the prevention. So what is this new initiative specifically hoping to tackle, Aarif?
So I think the nub of the problem here is that we are seeing a proliferation of atrocity crimes internationally. So right now, 1 in 5 countries is either experiencing atrocity crimes or there is the serious risk that they will occur. Now, the get out clause, not just for the UK, there are several other states that adopt this position, Germany included, is that in their view, they don't want to label something or categorize a particular atrocity crime as a crime against humanity or genocide or war crimes. And the reason they don't want to label something is precisely for the reason Christine raises, is it suddenly engages your obligations. And so the get out clause for a state is to say, well, we're not competent to deal with this. Genocide is for courts or tribunals. Now, of course, in the instances we've just talked about, whether it was Bosnia, whether we see Ukraine or the situation in Israel and the occupied Palestinian territories, there are often mechanisms available to utilize. So you have the International Criminal Court sometimes, you have the International Court of Justice, but the same states that say that this is a matter for international courts or tribunals are the same states that will not utilize those same mechanisms that are available because, of course, then it might get categorized and then you have to do something. But actually, you can roll back all the way to 1948. Why were these instruments created? They were created to prevent them happening in the first place, given the horrors of the Second World War. And determination of genocide is for states. It's for the executive to make a decision. The instant they learn of a serious risk, they must use all means reasonably available to them. And therefore, the biggest problem we have right now when it comes to enforcement of international obligations is domesticating the duty to prevent within our domestic framework so that that question becomes justiciable. Currently, there are very few states in the world that are domesticating these obligations in a way that a determination can be made that there is a serious risk and therefore governments have to do something.
Yes, I absolutely agree with Christine and Aarif as well that, of course, the trigger for the duty to prevent is the serious risk of genocide. And indeed, the 2007 judgment in the case of Bosnia very clearly explains the duty to prevent genocide. And as we were engaging with the UK government in relation to the duty to prevent genocide, we put to the government precisely this argument. And the response was, I'm sure I can find a link to the response, it's all public, that the government does not recognize that this is when the duty to prevent genocide is to be triggered, that it applies only to the case of Bosnia. And we've been having back and forths for a number of years, explaining that this is the explanation of the duty to prevent genocide. And unfortunately, this was not accepted. And you will see also that 2 years ago, Baroness Kennedy tabled a bill, the Genocide Prevention and Response Bill, which I also co-wrote. And this is precisely to ensure that the UK government has mechanisms that will enable monitoring of early warning signs and risk factors, so that then the UK has all the mechanisms that are needed for the UK to be able to identify the serious risk of genocide. At this stage, we don't have this kind of mechanisms in the UK. The US is doing much better, especially with the Early Visa Act and the mechanisms and the approaches that it introduced in the US. But unfortunately, the UK is still far from where it should be, so many decades after the Genocide Convention. And also, of course, we are talking about the duties under the Genocide Convention, but soon, hopefully soon, although it's going to take some time, we'll have the Crimes Against Humanity Convention as well, which will impose duties, similar duties as the Genocide Convention. And this is the time right now to start having those conversations in terms of how are we implementing our duties under the Genocide Convention? How are we going to implement our duties under the new Convention on Crimes Against Humanity? They're not going to implement themselves, and they're not going to implement themselves if we continue to deny the existence of the trigger for the duty to prevent, and if we continue to reject the argument that we need to monitor early warning signs and risk factors. Prevention is not going to happen on its own. We need to have mechanisms. We need to have strategies, policies, strong laws as well that are giving effect to the duties, whether under the Genocide Convention or under Crimes Against Humanity. So there's a lot of work that needs to happen to ensure that we are equipped to do this important work.
Just to add to what Evelina has said, I think the UK is by no means unique in the sense of having failed to really uphold its international obligations. I think across the board, with the proliferation of armed conflicts, the proliferation of international crimes, the lack of accountability, the failure to prevent, you can look at those issues pretty much in the round. I think the UK government is being pretty piecemeal and partisan. There are some very good initiatives in isolation. They've obviously, been a pioneer, for instance, looking at modern slavery or looking at initially the Women, Peace and Security agenda, which I'm sure Christine can speak to in further detail. But I think we're now at such a critical juncture in international law where institutions are being delegitimized, defunded, and the rule of law is being permissively broken pretty much everywhere we look at, that we can no longer do business as usual. And the standing group's mandate is to consider all of these issues in the round to see what are the practical solutions to some of these problems. And just to take the example that you raised in terms of the Genocide Convention, that there is a bill, it's been presented to Parliament several times as a private member's bill called the Genocide Determination Bill. Now, that bill is designed very, very clearly and quite fairly actually to the government, so that essentially the duty to prevent is completely operationalized within the domestic framework. And the way it's done is that the Secretary of State gets an opportunity to decide where there is a serious risk, to make a determination of whether there's a serious risk genocide is occurring or it's not. And if the Secretary of State fails to do that upon a request from Parliament, then that issue becomes justiciable. A court can make a preliminary determination in the UK to see whether or not genocide is occurring. And if the court makes a determination, then the Secretary of State is further obliged then to see what they are going to do, to do what was in the language of the International Court of Justice, to use all means reasonably available. And the Secretary of State can choose to do that or not. But of course, at least these issues will have been aired. They will have been looked at both legally and politically. And we can't say that nothing was attempted to have been done in respect of a really serious international crime.
And Christine, you wanted to add in on this question as well.
I was just going to add that I was really glad that Eweli mentioned the negotiations that are going on with respect to the Crimes Against Humanity Treaty. Now, it's still quite a long way down the track. And of course, once it actually gets adopted as a treaty, the UK will have to consider ratifying, becoming a party to that treaty. And then I think there'll be a very important process in, again, ensuring domestication of that treaty as it comes into force internationally. But I was also going to add something else that just gets completely ignored, I think, by the government, which is that the Common Article 1 of the 4 Geneva Conventions that gives states the obligation to respect and to ensure respect of the requirements, the obligations within the 4 Geneva Conventions, which essentially relate to war crimes. And many of the atrocities, of course, are in fact war crimes as well. And so an emphasis on that second part of Article 1 of the 4 Geneva Conventions to ensure respect. Again, going back to Eweli, you said the back and forth towards the UK government not accepting the obligations. I think that they have also not wanted to take the wording ensure respect to mean that there are obligations upon states to take action. And indeed, the provisions relating to universal jurisdiction, essentially, with respect to grave breaches of the Geneva Conventions, again, is something that is too often just overlooked, I think. Very, very few, that goes back to punishment, but very rarely do we actually see the jurisdiction that is laid down internationally and then in domestic legislation relating to prosecution of grave breaches of the Geneva Conventions.
And there's another thing, even if you get all these things internalized and codified, there is also different countries and different courts decide differently on that. We saw that fairly recently when you had the case about exporting F-35 parts to Israel, which in the UK, judges ruled that they could continue, while in the Netherlands we had almost carbon copy of this case where Dutch judges decided that there is a possibility that it's being used for war crimes, and therefore the Dutch government was not allowed to give a blanket permit for export.
Yes, I think there's a bit of nuance to the decision of the High Court in that matter. I think the judges were very clear that the question they were not deciding was whether or not the UK could send arms to Israel. The reason being is that in September of last year, the UK government for itself decided that there was a serious risk of the violation of international humanitarian law, and it would suspend 30 export licenses. The issue the court was deciding in this case was whether or not some parts of an F-35, which were part of a broader international agreement and framework within which the UK was a contributor to that, whether the UK could and should pull out and could prevent, for instance, Israel acquiring those weapons. Now, we weren't counsel on that case and we can't really comment on it, but actually the case goes to the heart of what we're discussing right now, because the one thing the judges did say is that the question of whether or not the duty to prevent under the Genocide Convention was engaged was not justiciable. And it was not justiciable because we don't have a domestic framework in place. And the judges also said that it was really difficult for them to assess what sort of assessment in terms of anticipation and risk assessment they had carried out in respect of atrocity crimes allegedly being committed in Israel and then the occupied Palestinian territories. And you can read the judgment that the UK government was quite clearly not doing pretty much any of the assessments that were required, even though it made a determination later that there was a serious risk of international humanitarian law violations. So really, in a practical sense, the issues that we are considering at quite a macro level are alive and engaged in quite specific cases in relation to specific situations. And unless we resolve these big macro questions, we're going to be constantly faced with this question, what is our government doing? And is it consistent in applying international obligations which are binding?
That's so interesting. And I followed the Dutch case in a lot of detail, not the UK case so much, where the essence of the Dutch case in a way was the same. It was about parts of these F-35 fighter jets that were potentially being used to carry out missions in Gaza. And the argument from the Dutch government was also, we can't just withdraw from this international program. And even if we do withdraw, they'll get it from somebody else. And the Dutch judges decided that this is then EU legislation about making sure that no war crimes can potentially be committed with the weapons you deliver, that those were heavier than these international obligations. And the Dutch government's big argument was, we as a government should make this determination. So it's an interesting discussion, but I understand your point that you need this kind of new initiative to have this put in law so that there is also more clarity on who decides what is an atrocity and when this engages, because the big argument of the Dutch government was also no court has ever made this determination.
There's a part of me that feels that we are discussing, the big issues here, but I keep on wanting to get back to some of the practicalities, which is, do we need somebody in the government whose responsibility it is to say, here's a problem? And who should that be? Is the problem that civil servants don't have this on their agendas and that they don't have to tick a box or whatever? I mean, what are the practical things that need to change? Is it that just the law needs to change and then it will all be fine? Or is it actually some actual practices in government? I can see Ewelina sort of raring to go. Why don't you kick us off on this part, Ewelina?
Thank you very much. Of course, the Genocide Prevention and Response Bill contains several recommendations in terms of what should change. You asked a question whether we need somebody in government who is responsible for the issue. And indeed, that's precisely the case. We need a minister who takes the overall responsibility over atrocity prevention, atrocity responses. That's part of the bill as well. Right now, we always hear from FCDO that everyone at the FCDO has this responsibility. But there's this Polish saying that if everyone is responsible, no one is. Because they'll be always pointing at somebody else, always blaming somebody else. And having one person will help us to also make sure that this person is responsible and accountable if something goes wrong. But of course, the Genocide Prevention Response Bill contains several other parts, and that's making sure that we have a team at the FCDO with capacity and resources to be able to monitor early warning signs and risk factors. At this stage, we don't have this kind of team. We have a small hub working on atrocity prevention, but they don't necessarily have the support and the capacity to be able to do this monitoring that is needed for us to be able to identify the serious risk of genocide.
Yeah, we love our acronyms here, but the FCDO is not one that is familiar to me, so I think maybe also to the listeners.
Of course, when I talk about FCDO, of course, I mean the Foreign Office here in the UK. The Foreign Office has a small hub working on atrocity prevention. From what we know, this is a group of 3 people, wonderful experts, of course, but at the same time not necessarily having the capacity and resources to be able to do the fundamental work that will enable the Foreign Office to be able to identify situations at serious risk of genocide or other atrocity crimes. And then, of course, we need better coordination and cooperation between the different departments in terms of responding to atrocity crimes. The bill is based on the Elie Wiesel Act from the US. And what we appreciated with that bill was, for example, the element of transparency. So the State Department in the US is to publish annual reports identifying all the situations that they monitor that are situations of atrocity crimes, and also identifying what exactly they are doing to respond to them. And this was very much something that we wanted to replicate here in the UK with the Genocide Prevention and Responses Bill. Another aspect is, for example, education on atrocity prevention to all who are working at the Foreign Office and also embassies around the world, to make sure that they can spot early warning signs and risk factors. And I'll give you one example of something what happened in the past, and it just shows the importance of the education on atrocity prevention. Back in 2011, the Border Control published a report about situation in Iraq and identify the horrific treatment of the Yazidis, Christian Shabak communities, identified that they've been called devil worshippers, infidels, and so on. That was 2011, and a few years before, of course, the genocide against the Yazidis, as we know it. And at that stage, somebody within the government should raise the red flags and say, actually, that's an early warning sign, risk factor of atrocity crimes against the community. This community, especially the Yazidis, but also Shabak communities, Christians, have been persecuted for many years. There always has been impunity for the atrocities. We need to look into it more, but nothing has been done. Nothing happened, unfortunately, on that front. And it's an example of showing us there needs to be a culture change at the Foreign Office, embassies around the world, especially in countries where we know that there is a risk of atrocity crimes. So it's not only one bill, policy change, reform of certain aspects of the law. There is a whole culture change that we need. And Aarif mentioned that, of course, the UK is not the only country failing in atrocity prevention. That's true. But at the same time, we need to start somewhere, and we need leadership on the issue. We can't really look at the US for leadership on those topics. And UK, and especially the current government, made wonderful promises when they were still in opposition, supported the Genocide Prevention and Response Bill, supported the Genocide Determination Bill. So there could be some leadership coming from this government. And we would like to see that. And we are there as the standing committee to support them in this work, to provide the research, to provide in-depth expertise on the topic, and ensure that they are equipped to proceed with all those different recommendations.
You mentioned the importance of leadership. You mentioned the importance of coordination across the different departments of the Foreign Office. Well, all of this was attempted with a very big initiative with the Prevention of Sexual Violence in Armed Conflict initiative that was launched by now Lord Hague, then Foreign Secretary of the United Kingdom, back in 2012. And I think very much the aim of that was precisely to change the culture, to have sexual violence and armed conflict recognized for what it is. It is a very good example of an atrocity crime. And following through from that, there was a Prime Minister's Special Representative on sexual violence and armed conflict. That Prime Minister's Special Representative liaises, works closely with the Secretary General of the United Nations, Special Representative on Sexual Violence and Armed Conflict that reports regularly, got a big office and reports regularly to the Security Council in the United Nations. So a number of the different mechanisms were there, and also leading to the United Kingdom initiating declarations that they got many other countries to sign up to with respect to various obligations on prevention and punishment, elimination, eradication of sexual violence and armed conflict. So, I mean, I'm giving that all as an example, but of course the reality also is that I think that subsequent prime ministers, special representatives, and they have worked and they have continued. We had the big conference a couple of years ago on prevention of sexual violence and armed conflict. So it has continued over these, 12 years now. But nevertheless, as we all know, sexual violence and armed conflict continues at horrendous rates, and in fact has increased in many type situations. And again, talking to people within the Foreign Office, there seem to be a number of different bodies. It's split between the Ministry of Defence and the Foreign Office. There are different bodies within the Foreign Office who work on it. I'm not sure whether they all know if they coordinate or cooperate with each other. There's a big consultation, in fact, happening tomorrow on the Friday on the topic. So I find myself quite conflicted in that a great deal of what you were talking about, Evelina, has actually happened in that particular context. And yet, clearly, still, we don't have what is needed at the end of the day to really to have effect and to really ensure implementation of the international law relating to prevention of sexual violence and conflict.
This is, Aarif, where we're going to get you to jump in and tell the doubters here who suggest how this new body would help and what support you might give and can get, to jump in and say how that would change what we see indeed with sexual violence in conflict, which gets a lot of attention and especially media attention, but it doesn't get a lot of concrete things happening. So how would this atrocity crime prevention work better, or should work better? How are you going to prevent the same thing?
I agree with Christine that some of these issues are long-standing, and the fact that they're not working is also not particularly new. So the International Development Committee, for instance, had an inquiry in 2022, and they found, and I quote, that the UK atrocity prevention programme currently lacks a budget, it lacks a policy, it lacks a strategy, and it lacks a means of institutional coordination. Now, those were members of parliament who had sat for a great deal of time, had taken a huge amount of evidence from civil society and policymakers and all people working in this space. And this report largely remains unimplemented. And really, we all ask ourselves the question of why can't this work? And that's really why we have convened. I think the Romans said that necessity is the mother of innovation. And so I think we all have a similar mindset that something needs to be done differently. And therefore, I think what we are seeking to do is to bring together like-minded experts and professionals as a committee who specialize in these areas to look at what are practical recommendations, from anticipating atrocity crimes, preventing atrocity crimes, to responding to atrocity crimes, and then looking at these macro issues of allocation and ministerial responsibility and policy outputs. And I think the key link here, and what's different, is that the standing group obviously has this committee of lawyers and practitioners and academics, but also we've got cross-party support. So there is an advisory board, which our numbers are increasing, to say that, these are influential parliamentarians who care about these issues, who have opined on them, and by coming together, we can make a concerted and consistent effort on some of these issues, both looking at these issues in the round, but also looking at specific areas or situations where we might intervene and say, look, this is a clear situation where there is a serious risk of atrocity crimes. There's no shortage of them right now, but these are some practical things that you ought to do and you ought to do right now. And I think there's a lot of goodwill from the work we've done in the past, for instance, in relation to the Genocide Determination Bill, where we had hundreds of parliamentarians supporting that. Now, I think the landscape today in terms of preventing and responding to atrocity crimes is a little bit different. We are in quite a politicized environment because people take different positions on armed conflicts in the Middle East. They see that when you categorize crimes as genocide or war crimes or crimes against humanity, that there is some political fallout from that by virtue of categorization. And so I'd say that there's also the polarization in respect of your position on an armed conflict has also meant polarization within this space. So I think there isn't the kind of really strong support on these issues when it comes to specific situations. But I always say, well, look, if you can't support it in that situation, what about when that situation involves us, or if it will affect us in one way, shape, or form? And so what we are trying to do is to navigate quite tricky political environment by saying, look, we need consistent rules. We need rules which are verifiable and implementable. And then we need to be able to enforce them, and ideally in the courts, so that we can depoliticize the landscape when it comes to preventing and responding to atrocity crimes.
I absolutely agree with Christine that PSVI is an example where we've seen so much energy at the very beginning, so much action, but unfortunately, in few years, it all disappeared as we saw it. And there was a report a few years ago saying that it started very well, but now we don't necessarily see that much happening. One of the challenges that we've seen in the UK has been also the leadership change and leadership changes. I think we need to emphasize it to our listeners because, of course, even under the Tory leadership, we had so many prime ministers, so many foreign secretaries, so many ministers responsible for a number of topics that we are discussing. With the change of leadership, there are also changes in priorities. And PSVI was at some point one of the three priorities for the Foreign Office. And then it dropped from those three priorities. And then we saw it as well that it was disappearing from the discussions. And also that translates into the assistance that various projects were receiving. Over the last few years, we've seen UK aid dropping from 0.7 to 0.5. Now it's dropping to 0.3. Several of those projects supporting victims of PSVI will be affected. At this stage, we still don't know, but Christine mentioned that there is a consultation this Friday specifically on PSVI. So these are the questions that have to be asked. Which projects were affected and how does it translate in terms of the support to victims and survivors of those horrific atrocities and or prevention efforts, whether of conflict-related sexual violence or atrocities more broadly. And something what we are proposing with the standing group will be proposing, and it's different from the PSVI, is very much ensuring that we have also laws that introduce those mechanisms that are outlined earlier. And then it doesn't really matter what are the leadership changes, those mechanisms will be there. In terms of the support to those mechanisms, of course, there will be change from leader to leader, from leadership to leadership. But ultimately, once those mechanisms exist, it will be easier to engage. It will be easier to, of course, continue the important work. It is not going to change from leadership to leadership. So this is a different approach that we are hoping to see over the next months. But at the same time, of course, we'll not know whether this is going to succeed at this stage, of course, but nonetheless, we want to try a different approach and hopefully, of course, to see a change that is urgently needed.
I'm feeling very seesawy as I'm listening to all of you. Like, this is really important, but it's proved how difficult it's been to make it work. Yet there's a lot of goodwill and a lot of people who want to make it happen, yet the challenges are there. So I don't know where I stand at the end, but we do have to wrap up the podcast. So Steph had a suggestion of a different way to do it.
Yeah, we usually ask what didn't we get to, which we should have asked, but we're going to give you a different thing. I was thinking to give everybody a kind of pitch moment where they say what they most want to see change in the way it's going now and how this new initiative could achieve it. And this is the journalist in me. I need a nut graph and I need it very short. I think Aarif is probably looking like he has a plan to tell me this shortly and sweetly.
Where the worlds of law and politics converge, of course, you are bound to have difficulties. And I'm at heart a realist and pragmatist. And I'd like to say, look, we will obviously consider the UK's approach to anticipating, preventing and responding to atrocity crimes pretty much in the round as far as we can. But ultimately, I think we will succeed on whether we can get a change in the primary legislation to operationalize international obligations like the duty to prevent, like the duty to not aid and assist atrocity crimes, like the duty to coordinate in order to bring about the end of a wrongful international act. And I think whilst we may not succeed on achieving everything that we want, I think we would be satisfied in the sense of getting some movement by the government on legislative change so that it's closer to its international obligations, which are binding on it.
Ewelina, you can have one pitch.
I would like us, of course, to ensure that we put victims and survivors at the center of all those efforts. Ultimately, we're not talking about abstract atrocity prevention strategies, policies, laws, and all of them are to protect individuals from future atrocities. And I think we need to keep that in mind. It's not about any political agendas of one party. It's not about leadership more broadly. everything what we are hoping to do is to ensure that we prevent pain and suffering and death, of course. And as long as we keep the victim survivors at the center of all our efforts, I think we should be able to succeed. And I will leave you with one quote. And I'm currently sitting in an office of a wonderful parliamentarian who is doing incredible work on atrocity prevention. And the quote that he has on just behind his desk is, "We learn from history that we do not learn from history." And this is something what we need to address. We should know by now that atrocity prevention is the only way to prevent suffering of victim survivors, whole communities. And we repeat never again, again and again and again. And we do not learn. And we need to end this vicious cycle.
Well, I agree with everything both of them have said. I think I'm an international lawyer at heart. And what we're seeing at the moment is international law being abused, being manipulated, being reinterpreted essentially to dismiss its important messages, to dismiss the notion that it's international legal obligation, it is state responsibility. And I think that what we have to do at the moment is actually see this moment when there is so much abuse of international law to say, okay, this is a moment of opportunity. This is a moment to use international law as a tool of resistance against the debunking that is going on in so many situations, and to really push and to use initiatives such as this to make that message absolutely strongly. That international law isn't just something that can be cast away, dismissed. It's there precisely to support victims, survivors, and to put states on account for their behaviours. Let's try and grasp this opportunity.
Thanks very much, Christine. What you said just chimed with something that was going through my brain before we came into this podcast. I noted that a group of former State Department people, ambassadors and so on, have just put together an alliance for diplomacy and justice, and they're very much concentrated on what's going wrong at the State Department. But I was thinking, okay, are we actually starting to see the moment now where everybody says this has got so bad everywhere that we're now actually going to start working together and kind of nail our colours a bit more to our chests and say what needs to change? So we may have changed the normal way that we do the end of the podcast, but we always ask a final question for all three of you, which is there anything that you've been watching, reading, or listening to that you would like to share with our audience? It can be something that is in the field or something that you use to get away from the field. And I can see Aarif is reaching out to grab something. You start, Aarif. What's in your hand?
I'm reading a really interesting book, actually suggested by a client of mine, called Soul of a Citizen by Paul Rogat-Loeb. And it's a brilliant tome on how change happens and how unlikely change happens. And it's really worth reading because it debunks this idea that heroes just suddenly fall into our laps, and it reinforces the practicality that hope is something that we decide to do rather than that we have. And so I'd really recommend this book because there's lots of good examples of how change happens and unlikely change happens. And I'm sure we will use some of these techniques in respect of our work in terms of the standing group.
Christine, do you have something to recommend or something that you do just to get away from the international law?
What do I do to get away from international law? Go walking. Go walking in the countryside. Go walking where, on the one hand, it's visible what's happening in terms of climate change. And we know as well how that also feeds into atrocities. There should be butterflies, there should be bees, and there aren't in so many places of the countryside. But at the same time, it's peaceful, it's quiet, it's a moment to think. So I think that is my takeaway.
Ewelina, we started with you and we're going to end with you.
I will add a TV series to the mixture of the different proposals, and it's a Netflix TV series, so it's being shown on Netflix. It's called Black Earth Rising. and it's about the Rwandan genocide and which voices. I think it sends this message that we always need to rethink which voices receive the attention, are being given the platform, which voices are denied the platform at the same time. And the multitude of different stories and narratives that of course we should know, especially as we work on the different situations. And victim survivor central approaches, of course, to ensure that all victim survivors are given the attention that they require, are provided with assistance, etc., even though it means so many different narratives out there. Something to think about, not necessarily to relax, I would say, but it adds to the book recommendation and the walking proposed by Christine.
We've had it recommended on the podcast before, that TV series, but I think it's also very interesting, the new angle you gave us to look at it, because we hadn't looked at it from that. So I think I might rewatch it if I feel up to it this summer. Thank you very much.
Thank you for having us.
Thank you very much for the opportunity.
Thank you very much.
Just to say that if you are enjoying this podcast and you'd like to give us a bit of extra support, you can head over to our Support Us page where you can give us a tip, or you can follow us on Patreon and you can download our newsletter. And we really appreciate everybody who gives us a bit of extra support there.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie van den Berg, in partnership with the Hague Humanity Hub. Music is by autonautics.com. You can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.